Hi, this is Brad Wiewel with the Estate of the Union. We are here talking with Melissa Donovan. Melissa is one of our fantastic lawyers here at the Wiewel Law Firm, and we are going to talk today about a very challenging legal topic, but it's also a challenging personal topic, and it's getting to be a bigger and bigger personal challenge, and that's special needs planning. We have many clients, and for you listeners out there, you probably know many people that have a child, perhaps another loved one, who suffers from some form of disability, some special needs, whether it's autism, Down syndrome, it could be the result of an accident along the way, brain injury, someone who can't take care of themselves, perhaps physically, maybe they can't mentally or emotionally. This is a very difficult situation for everybody involved, and it has tremendous legal consequences and aspects to it. And Melissa Donovan is a CELA. And a CELA, Melissa, what does that mean? S-C-E-L-A, not S-C-E-L-A.
Not S. So CELA just stands for Certified Elder Law Attorney. And I know that a lot of people kind of hear that and think, oh, she works with the elderly.
Right.
Which
you
is
do.
part of
Which
it,
you do.
Which is part of it. But a lot of it does have to connect to special needs planning. And,
Right.
and yes, some of that is with more elderly clients, but a lot of that is with, like you were saying, parents who have children with special needs, like you were saying, autism, Down syndrome, cerebral palsy,
Right.
several, variations on things. And that really just kind of entails being a little bit of an expert on, government benefits and Medicaid and Social Security and how all of that kind of combines together.
Well, I'm going to say this, Melissa. Melissa's very modest. It's not just a little bit of an expert. Melissa is an expert. There are only, out of the 25 million people in Texas and the 110,000 lawyers in Texas, there are only about 30 CELAs in the state of Texas, and Melissa is one of those. So she knows this stuff better than anybody else in the state of Texas, which is why we're so thankful to have her at the Wiewel Law Firm. So let's kind of pick her brain on this. Is that okay? Let's see, Melissa, plumb the depths of your expertise here. And, we do have a lot of clients with children or other loved ones with special needs. And how does that affect their legal situation?
So there's several kind of things that go along that spectrum when you're dealing with a family that has a child with special needs. And, part of it is their estate planning. A lot of the times I get people who make an assumption because they do a lot of, seminars, and they hear from the school, and they hear, I've got to get a guardianship. So it kind of ranges that spectrum from making sure that our clients have the proper estate planning in place, making sure, do they need guardianship when their child turns 18 or not? Sometimes it entails having to do special things for the actual maybe adult child if there's a situation where someone maybe wasn't born with a disability, but like you were saying, they're in an accident or something occurs that they become disabled later on in life.
Right. So let's just kind of break this down. And I will say this to you listeners and viewers that this isn't going to be the only program we do on special needs. This is such a vast area of the law. We're going to kind of do a little overview today, and then we'll have Melissa back with other kind of more detailed analyses of special needs. But let's start, Melissa, with the estate planning piece, because there are, again, hundreds of thousands, probably millions of people out there that have a child with special needs. And what the heck does that have to do with their estate plan? How does that add more work, subtract more work? Is it more complex? Talk about that, please.
It certainly can lead to a bit more complexity within someone's planning. And basically what the situation is if I have, let's say, 2 children, and I have one child who, might be neurotypical, and really my concern is making sure that I'm not going to, hand thousands of dollars or maybe hundreds of thousands of dollars to a 12-year-old, because not even an 18-year-old would be a good idea, honestly. So we want to make sure they're protected on that end from making sure there's an adult who can manage their money, but eventually at some point they can manage it.
Where you used a term, I'm going to try to define this, neurotypical. So I am 68 years old. I'm a young 68-year-old. I tell people I'm in my late mid-60s, right? Neurotypical is not a term that a lot of people would understand. I'm going to use a term that's probably heinous and wrong. That would be a neurotypical person would be somebody who's normal.
Right, someone who doesn't necessarily have an
Special
incapacity.
needs. All right. Again, somebody who has sufficient brain power to manage their own affairs when they're of age and all that. Okay,
yeah,
great.
Absolutely.
All right, thanks.
So whereas on the special needs side of things, it has to go a level deeper, because not only do we maybe have a situation where my child's not going to have the mental capacity to be able to manage money, but also they might not be able to in terms of maintaining benefits. And that's the big key when doing estate planning and being concerned about special needs, because a lot of our clients and a lot of people who have special needs children are not as familiar with the Medicaid, Social Security systems while their child's a minor, because they're counting the parents' assets.
They don't need to, because
Right.
there's no impact. They go to school, they may be in special ed or have special access to educational opportunities that they need because of their disability.
Right.
But when they turn 18, that's kind of a significant age.
Exactly,
Right.
because as soon as someone turns 18, still in the eyes of the law, they're an adult. So their parents' assets, their parents' income is no longer going to be counted against them. So a lot of these children, when they turn 18, SSI becomes an option for them, Medicaid becomes an option for them, and especially with the Medicaid, that can be incredibly helpful towards paying medical costs depending on the situation. So the idea with building in the special needs planning to the parent's estate plan is making sure that if the parent passes away, their assets are not going to disqualify their child, because we want to make sure that they continue to have the benefits that they have available to them, and that it kind of entails special needs trust planning and maybe some other stuff that gets built in.
Okay, great. So let's break this down. Break it down. When someone turns 18, we talked about benefits. We're talking about government benefits, right, from both the federal government and the state government.
Exactly.
All right, and each state has their own little rules. I understand that, right? All right. So they turn 18, and they're now, again, as you said, an adult. I wasn't much of an adult when I was 18, but there you go. I wasn't much of an adult when I was 30, actually. I finally started to mature around 30, but they now had to get government benefits, from what I understand. They can only have so much money in their name
Correct.
that they own.
Correct.
All right. And once they're over that limit, then they get disqualified from government benefits?
They could, even if just temporarily, but that
Okay.
could be kind of disastrous depending upon the health situation.
Because if they're eligible, they get all these things. Medicaid, you mentioned that. We'll talk about that. SSI, what is that?
So SSI stands for Supplemental Security Income. A lot of people, most people are familiar with Social Security as kind of a blanket.
I turn 65 or whatever, I start getting Social Security, right?
Exactly.
Okay.
So that's retirement Social Security. Then there's disability Social Security. And there are two forms. There's SSI, which is what more often we're dealing with in this scenario, and SSDI, which is for people who have had work credits and history and maybe become injured or whatnot. They're two different programs.
Sure.
But with SSI and with Medicaid, like you were saying, they are means-tested programs. So what happens is you have to maintain below a certain limit in terms of what your income is coming in, what your assets are. And that's why, if mom or dad pass away and leave, Johnny, even just $10,000, it could completely disqualify benefits from that child.
$10,000, ladies and gentlemen. This is important stuff. This is the problem from an estate planning perspective with special needs planning. Your child can only have so much. We'll get to how much in just a minute, but they can only have so much money. And if you die, and you leave them more than that amount. And I think the amount's about $2,000.
On average.
Right.
It varies slightly program to
That's
program.
$2,000. That's not $20,000. That's not $200. That's $2,000. Then you will disqualify them from many, many, if not all, of their government benefits. So this is as serious as it gets in estate planning for anyone, but especially families with special needs kids. If you don't do the planning, you could ruin your child's life going forward, and that's a serious, serious thing. So, Melissa, I don't think I'm overplaying this, am I?
No, I would not say that you're overplaying it.
All right.
No, it's a serious issue. It's something that you want to make sure you're taking care of.
So how much money can somebody have to qualify for Medicaid and, as you said, SSI?
So there are various programs within any state's Medicaid agencies. So like here in Texas, we have upwards of 35 programs that are available. It does kind of vary, but on average, kind of if you're given a round number, we usually are looking at about $2,000 in countable assets. And I know we probably don't have 17 hours for this conversation, so we'll kind of leave it at on average, but there are things that are counted, there are things that are not. So we want to make sure that if we are in a situation where someone's passing away or someone's gifting money, that there's the proper vehicle to do it.
Sure, sure, sure. So, serious stuff. What would be the proper vehicle?
So typically what this is going to look like is what's called a special needs trust.
Okay.
And the way I like to explain it to clients might seem kind of scary because most people don't really enjoy like middle school biology and stuff. But if you remember back to middle school when you had those quadrants, when you were doing your chromosomes and your genomes, and it's like you got your y-axis and your x-axis.
Mitosis and meiosis, all that stuff.
You know, you're
Holy
looking
cow.
at those. So it's really kind of four potential things, but you're looking at an existing trust,
Okay.
a testamentary trust, and then a first party and a third party.
Okay.
Got all that?
Good, good, good. Four things.
Primarily.
Trust while I'm alive, trust when I die, first party trust, third party trust. This is okay. So batten down the hatches out there, everybody, because this is. But this is complex, as you can already figure out. Holy cow! That's why Melissa is an expert in this. This is why there's only 30 of these in the state of Texas, because this is so complex stuff. But let's keep it simple for our audience today, and then again we can go back in subsequent podcasts and drill down deeper into each of these quadrants, all right? So let's start with a prototypical couple. That's a nice word, prototypical. You used typical earlier. A normal couple that has a special needs child that is either an adult or a minor. I think my understanding it doesn't really matter when it comes to their estate planning to a certain extent, but what do they need to have in their will, or maybe they have a revocable living trust?
Right.
What do they need to have to make sure they don't inadvertently disqualify their child?
So generally speaking, and this is the most common, is we call it a testamentary special needs trust.
All right.
That is a special needs trust that is built into mom and dad's, like you were saying, whether they have a living trust or they have a will-based estate plan. The idea there is that that trust doesn't exist yet. It's only going to come into play when mom and dad pass away. And for a lot of families, if they don't expect other people are going to be leaving money to their child, they don't think there's going to be an issue on that kind of thing. You know, aunt wants to leave money, grandma wants to leave money. If the only money they're expecting to go to their child is their own money when they pass away, that can be a great avenue to go, because it takes care of making sure if I have a special needs child and I pass away and my will has that special needs trust on the testamentary level, when I die, my money's for that child's going to go into that trust.
Okay, and protect them.
Exactly, it's going to
and
protect
the money
their
can
benefits.
be used to take care of them.
Yeah, so with
Okay.
the special needs trust, the idea is that that trust is allowed to pay for the things that Medicaid and Social Security aren't meant to pay for.
All right.
So many times with Medicaid, there are certain therapies or things that can be done medically speaking that aren't actually covered by Medicaid. So a lot of parents like the idea of using it to pay for those additional therapies that
Sure.
they might pay for on their own. Or you can use it to pay for what I call the everyday luxuries, the things that we all kind of enjoy and take for granted a little bit. You know, going to the movies, taking a vacation, having, cable or whatnot.
Well, and sometimes these are called luxury trusts. because they provide these luxuries, they can also provide, I think, better housing.
They can, and most
If
people
carefully
choose to. You
drafted.
have to be very careful, but yeah, it can be really beneficial because what happens with Social Security in particular is if, let's say, the benefit in a year is $900 a month, and you have a person, whether it's a trust or just somebody paying for it for you, if you pay for housing or you pay for it's food and shelter,
Okay.
and it becomes what's called in-kind support and maintenance, it will reduce that person's benefit by a third. But many times it's worth it to do that because the way we kind of explain it to clients is you might lose the $300 of the $900, but
Okay.
you could be paying the $1,500 a month rent.
Right. You
So-
can put them in a very nice place.
Right.
Okay. Sure.
Yeah.
Sure. So by tweaking this carefully, and again, this is why you need to go to an expert on this, and we'll give you some ideas on how to find an expert on this if you're not here in the Austin area to utilize the Wiewel Law Firm. This is very carefully drawn stuff by somebody, again, who knows what they're doing. So the Special Needs Trust, the money comes in, that child is cared for to the best of everybody's ability and can live in a very nice living situation and have a great life.
Yeah, and it
Yeah.
can really be beneficial. I mean, I have a client that we've been working with, and she had a special needs trust from years ago that didn't have those housing provisions and didn't think they could use it because they've been having her son in a private group home for quite some time. Private group home's not paid for by Medicaid. The money is in this special needs trust, so having those provisions to allow for that housing, she could have been paying for that private group home for all those years. So everything's a little different, but there are certainly beneficial things that can be built in there.
Okay, I'm going to take this to another level. Many people don't do any estate planning, haven't done any estate planning. Many people, if they're going to do any estate planning, are going to go to perhaps LegalZoom. They may go to, again, a lawyer who is a good person and probably a good lawyer in many places, but not this.
Yeah.
And you review a lot of things from other
Yes.
lawyers, and share some things about that, please. Or leave in LegalZoom.
Well, so not to sound biased, but I'm not a huge fan of LegalZoom.
Okay, sure, it's okay, it's okay.
But the thing with anything, in particular something like LegalZoom, is I think what people need to understand is if you go to something like LegalZoom or Rocket Lawyer or those types of things, you're just getting kind of a carbon copy legal document. You're not getting legal advice. Nobody's there to advise you on what should or should not happen. The biggest thing I know, myself and Ann Lumley, who does our probates here, we talk about all the time, people might have a will very simple, but it's not executed properly. Many times we say thinking you have something and not having it might be worse than not having anything
That's right.
at all.
That's
but when you have a special needs child, like you were saying, even if you have an estate planning attorney who doesn't really practice this, I know very, very good estate planning attorneys who they themselves will say, I don't do this when it comes to special needs planning, and they will refer out to someone who specializes in it because it is so important to make sure that those provisions that are built into that trust are correct and that it's done in the proper way because we say all the time, and we're not the only ones who say it, the law changes all the time, right?
Right.
Well, with Medicaid and with SSI, those types of government organizations, yes, the laws matter, but a lot of the rules are regulations, and those things can change like that.
Right.
So, I know that there have been situations where regulations have changed within, a couple of months, and it takes 6 months, 2 years. We still have a change in regulation here in Texas that's not technically in any written book. 2.5 years later.
Wow.
So,
Wow.
So you
Wow.
have to be able to know what's going on.
Okay, I'm going to take it again another step further, and I want to, again, make sure everybody watching or listening understands what Melissa just said about the criticalness of having a special needs trust in your will or your living trust for your child is critical. I use that word too much, probably critical. But there's another whole aspect that also must be done exactly right. And that's coordinating the retirement account and the life insurance that you may have with that trust too. Because if I have all this planning that Melissa's done for us,
Yeah.
and I think all my money is going to go to my special needs child in this way, but I haven't lined up my beneficiary designations on my retirement accounts and my life insurance, what happens on that?
It could be potentially disastrous, but it's really important because what will happen is, let's say you've done, like you were saying, you've done all the planning, you've got the special needs trust in the will, and you think, okay, I'm done.
Yeah, and check
You're
the
not
box
done yet.
and sleep through the night because you've done that very responsible thing, right?
Right, and what
Sure.
happens is that we all have these things in our financial life that don't necessarily flow through our will. They're what we call non-probate assets, like you were saying, your life insurance policies,
Right.
your retirement accounts. Those are always going to go by that beneficiary designation. That's the contract that you signed with that organization. So if, for example, your retirement account says, I give it to my spouse and my contingent beneficiary are my two kids, Sally and Johnny, but Johnny has the special needs trust in the will, well, you just gave the retirement account to Johnny, not Johnny's trust. So it's really important that once you have that in place, that you're following your lawyer's advice and going back, contacting your retirement company, and updating those beneficiary designations. So Johnny's retirement portion goes to Johnny's trust and not Johnny.
Well, and this is another reason why you need expert help with this because, again, there's a lot of great lawyers out there. But you're going to need to work with a lawyer that is going to give you the exact language, right? The exact language on how to put that on your beneficiary form at work or your IRA that you got or somewhere, or a Roth, or again, life insurance, because it's not just, you don't want to guess. I'm sure you don't want to guess. And we don't want you to guess. So one of the things we do provide our clients, and other good lawyers do too, is the exact language used. Is that right, Melissa?
Exactly.
Okay.
It's really important that that is done properly. You don't want that to throw off.
Right, right. So if all that works together and then the special needs person has that in place, who should be the trustee of that trust?
So this is one of the few scenarios where I will always recommend a professional to clients.
A professional.
So a professional would be something like a corporate trust company.
Okay. Like a
or
bank.
like a bank. Or
Okay.
maybe it's an attorney or a CPA.
Okay.
This particular kind of trust, you don't necessarily want someone managing it, being the trustee, who doesn't know all of those rules.
Right.
Because it's one thing to say, I'm okay with my sister being the trustee for Sally, who just has a trust for her health, education, and maintenance till she turns 25, and then she can do what she wants. There's not a whole lot of complexity for that trustee. Probably my sister could manage it.
Right.
But if I have a trust for Johnny, that it is so important that that trustee knows what they can distribute from the trust for and not disqualify Medicaid benefits, it is near impossible for any one individual, unless that's what they do day in and day out, to keep up with all of those rules.
Again, the unwritten rule that's been out for 2.5 years. I mean, who would know that stuff? But if you violate that rule, that could again lead to disaster.
Yeah, because what happens is, even if you have the special needs trust in place, and let's say you designate your sister as the trustee, and she happens to make a distribution at some point in time that Medicaid's not okay with, that Social Security's not okay with, it could negate those benefits, whether for 1 month, 2 months, or maybe even longer.
And they could get sued
Yeah.
because they didn't know and they did it in all good faith, and now they're getting sued, and it's a mess. So we have many clients who are reluctant, naturally reluctant, to want to use a bank as a trustee when my sister is here, and I trust her, and I don't trust, I don't know who this bank is, and I don't know anybody who works for the bank. I mean, I go through the ATM and my money's automatically deposited. That's all I know about this bank, right?
Yeah.
So what can be built in to that trust, Melissa, to allow the family to have, again, a professional trustee, as you say, which is a great term, but still have that aunt or uncle or other child, a sibling,
Yeah.
to have control over that.
So we call that person a trust protector.
Okay.
And I really do think that's a great term because their job is to protect the trust.
Okay.
So what they can do is if, let's say, I've got my sister and then I'm naming, whatever corporate trust company we're naming as the trustee, my sister can make sure that the trust company's taking care of my kid properly, making sure they're not charging too much. And if my sister, as trust protector, thinks that something's awry, she can request accountings from the trust company. She can kind of act as that managerial role without having to take the day-to-day responsibility of having to know all of the internal rules.
Sure.
And then if she really thinks there's a problem, my sister can fire that trust company and hire a new one.
All right, very good,
Yeah.
very good. In fact, there's a phrase out there in the trust company world, and I'm not even sure if you've heard of it. It's called the stand-up clause.
I'm actually no.
All right, so a stand-up clause, if this is really a fun little thing, is if a corporate trustee really knows they can't be fired and the family shows up at their office and needs maybe some money or some help with something, and the receptionist calls the trust employee and says, the whiny Wiewel kids are out there again and they want more money apparently, and that employee can, oh my gosh, they were here last year, weren't they? Yeah, they were last year, oh my gosh. They are kind of whiny, yeah, very whiny, oh my gosh. Well, tell them I'll be there a little while, and that person goes and gets another cup of coffee, checks the email, does a little social media, and then eventually stands up and goes out to see what's going on. But if that corporate trustee knows there's somebody in that family that can fire that corporate trustee and hire another one when the whiny Wiewel kids show up and the receptionist calls that trust company employee and says the whiny Wiewel kids are out there, that employee stands up immediately and goes out and tends to them because they know they can be fired. It's called a stand-up clause. So having a trust protector with the abilities that you're talking about, Melissa,
Yeah.
to get that trust company to stand up and salute, which is nice too, really goes a long way to making sure that your family is protected the way that you would want them protected. And nobody in your family will be more vulnerable to who knows what else is out there, right?
That is absolutely correct. Although I feel like I need to stand up for the Wiewel kids a little bit. They're not that whiny.
Thank you, Melissa. They really aren't too whiny. No, they have been in the past, but they're fine right now. In fact, Zach Wiewel is technically an attorney here at the firm, and his first day is Monday. So, holy cow, yeah. So thank you for that. I appreciate you clarifying that for our listeners. And my wife, Cindy, who's going, what the heck? Our kids aren't that bad, Brad. Okay, great. There's much more to special needs planning. You mentioned guardianships. You mentioned this thing called SSDI. We had a little visit before we started our program today, and Wade, who's our producer, mentioned ABLE accounts. Those are out there. It's a vast sea of information. What we're going to try to do for you in subsequent podcasts is break down those things with Melissa so that, again, if you have someone in your family with a special need, certainly you know somebody with a special need, virtually everybody knows somebody with a special needs child, then you'll be in a better position to understand things and maybe take action, because this is a place where action is required, action is critical. Want to take a brief second, talk about the Wiewel Law Firm. We're here in Austin, Texas, and we see people on a complimentary basis as a great general rule. Sometimes we do have an initial consultation charge, but as a general rule, we don't. It depends on the individual case, of course. Melissa is here. She is great. We've just heard her. You know how great she is now. She also, again, does a lot of our general estate planning, don't you?
Yeah, I absolutely do.
Plenty of people coming in to get a will, a trust, things like that. We have Rob Hugos. We have a total of 7 lawyers, and this is all we do. We don't do divorce. We don't do DWI. We just do estate planning and probate. You mentioned Ann Lummy. She heads up our estate administration division. So we'd be happy to help you any way we can. You can go on our website, which is texastrustlaw.com. and you can learn more about us. I want to say that we are, to use the word, a Christian-focused firm. We try to exemplify biblical values, and we'll treat you well and treat you right. And we are happy to help you in any way we can. So whether you use the Wiewel Law Firm or another law firm, the key to this presentation today is use somebody who knows what they're doing, especially in the area of special needs planning, so that it all works well when it needs to work well, right?
That's the important part.
And thank you, Melissa Donovan, for helping us today with this, and thanks for working at the Wiewel Law Firm. And ladies and gentlemen, we will see you next time. Thank you very much.